So we will call formally to start the meeting of the State Ethics Commission, a public meeting held on April 12th, 2012. The commissioners have all received the agenda as well as all of the material in due time for all of us to review, study, and question any of the matters that are come before us today. So with that, I will start by asking for approval of the minutes of the public meeting held on January 31st, 2012, all of which have been distributed to the commissioners. Are there any additions, corrections, suggestions? Being none, is there a motion to approve those minutes?
So moved.
And it has been moved, and there is a second. Any opposed? If not, the minutes will stand approved as distributed. With that, we'll move into the agenda, but I guess I should announce for the minutes as well. Commissioner John Bolger is not with us today, but we do have an ample quorum, and Commissioner Raquel Bergen is with us by phone. Going into the agenda, the civil penalty orders, Commissioner Volk, I think these are mostly consents, but certainly any commissioner can question any matter before us.
Excuse me, you need to
read my whole
okay.
thing. I didn't want to subject you all to this, but I will.
I know.
For the formality, pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to the said executive session or at the next meeting thereafter. Executive telephone conference meetings were held on February 15th, 2012, March 14th, 2012, and March 22nd, 2012, and an executive committee will be held today on April 12, 2012, immediately following this public meeting, to review matters that are by statute confidential, including the review and consideration of applications for 90-day extensions of investigations filed by the investigative division, to review completed investigations for the purpose of issuing final adjudications, and for the consideration of the assigned reviewing commissioner's recommendation to terminate certain preliminary inquiries. The review of pending litigation, which of course is confidential. With that, we will then move into the regular agenda. Under the lobbying matters, Commissioner Volk, I think you took the lead to go through these consent matters, and I would call on you to report.
Thank you, Mr. Chairman. There are 7 administrative penalty cases with proposed consent agreements for our consideration. The following 7 respondents are principals that failed to timely file 1 or more quarterly expense reports in their capacities as registered principals: Pennsylvania Rural Electric Association, Adelphoi USA, Renew Growing Greener Coalition, Lawn Care Association of Pennsylvania, Neiman Group, Interactive Travel Services Association, and CHHS Hospital Company, LLC, doing business as Chestnut Hill Hospital. In each case, the parties are in agreement that the respondents' transgressions of the lobbying disclosure law were negligent. The respondents have already filed their delinquent expense reports, are in the process of paying the agreed-upon penalties. Based upon my review of the facts, I am of the opinion that the consent agreements are proper dispositions for the respective cases, and I'd like to make the following motion. I move that this commission approve the consent agreement submitted by each of the following respondents and the investigative division, and impose the following administrative penalties. 1. As to Pennsylvania Rural Electric Association, an administrative penalty in the amount of $1,620 for its delinquent expense report for the 2nd quarter of 2011. 2. To Adelphoi USA, an administrative penalty in the amount of $3,600 for its delinquent expense reports for the 2nd and 3rd quarters of 2011. 3. As to Renew Growing Greener Coalition, an administrative penalty in the amount of $1,800 for its delinquent expense report for the 3rd quarter of 2011. 4. As to Lawn Care Association of Pennsylvania, an administrative penalty in the amount of $1,800 for its delinquent expense reports for the 2nd and 3rd quarters of 2011. 5. As to Neiman Group, an administrative penalty in the amount of $2,800 for its delinquent expense report for the 3rd quarter of 2011. 6. As to Interactive Travel Services Association, an administrative penalty in the amount of $5,700 for its delinquent expense report for the 3rd quarter of 2011. And 7. As to CHHS Hospital Company, LLC, doing business as Chestnut Hill Hospital, an administrative penalty in the amount of $9,135 for its delinquent expense reports for the second and third quarters of 2011.
That is the motion. Is there a second to the motion?
Second.
It is a second. The floor is open for any cumulative question, comment, or to any of those individual matters. From any commissioner? Seeing we're hearing none, all those in favor of the motion as presented, kindly respond by saying aye.
Aye.
Are there any negative-minded? And there are not, so those will pass. Moving on the agenda, the civil penalty orders. These two are all consent decrees, and I would call on Mr. Contino if you would just review those for us.
Yes, these are originally assigned to Mr. Bolger, but they were consent agreements negotiated by the investigative division, so I'll just go through them quickly. There are 5 additional consent agreements. They involve MTR Gaming Group, it's Mountaintop Resorts, Friends Hospital, Keystone Progress, Excel Pension Solutions, and Equiterra. And we would be looking for a motion to assess the following penalties in relation to each. $3,937 for MTR, $3,990 for Friends Hospital, $3,990 for Keystone Progress, $3,990 for Excel Pension, and Equiterra in the amount of $1,800. All, the first 4 for deficiencies of not filing their third quarter expense reports in 2011, and Equiterra for its third and second quarter. So these are matters that have been negotiated, consent agreements with the noted principals. So we'd be looking for a motion to approve those consent
Thank you,
agreements.
Mr. Contino. The following 5 respondents as recited by Mr. Contino, and even though it seemed maybe to those in attendance here that it was very quickly done, the commissioners have all of the information and the opportunity to review that before today. The following 5 respondents are principals that failed to timely file 1 or more quarterly expense reports in their capacities as registered principals. MTR Gaming Group, Friends Hospital, Keystone Progress, Excel Pension Solutions, and Equiterra. In each case, the parties are in agreement that the respondents' transgressions of the lobbying disclosure law were in fact negligent. Most of the respondents have already filed their delinquent expense reports, and the respondents are in the process of paying the agreed-upon penalties. Based upon my review of the facts, I am of the opinion that the consent agreements are proper, the disposition of these respective cases, and I would like to make the following motion. I move that this commission approve the consent agreements submitted by each of the following respondents and the investigative division and impose the following administrative penalties. Number 1, as to MTR Gaming Group, an administrative penalty in the amount of $3,937 for its delinquent expense report for the third quarter of 2011. As to Friends Hospital, an administrative penalty in the amount of $3,990. That looks like a bargain after $4,000. Really negotiated that one. For its delinquent expense report for the third quarter of 2011. As to Keystone Progress, an administrative penalty, again in the amount of $3,990 for its delinquent expense report for the third quarter of 2011. And as to Excel Pension Solutions, an administrative penalty in the amount again of $3,990. Should have played the number on that number. For its delinquent expense report for the third quarter of 2011. And finally, as to Equiterra, an administrative penalty in the amount of $1,800 for its delinquent expense reports for the second quarter of 2011. And all of those have been done by negotiation and agreement with the appropriate respondents, and I would so move approval. Is there a second?
Excuse me, Mr. Private, just to note for the record, for Equiterra, as Mr. Contino indicated, it's both the second and third quarters.
Who did what?
It's the second and third quarters of 2011 for Equiterra.
Oh, I'm sorry. Fine. With that amendment, there is a motion and a second, I think, someplace. The floor is open for any comments, questions, concerns as to the group or any individual company. There being none, all those in favor, please respond by saying aye.
Aye.
Are there any who are against the motion? There being none, the motion carries. Moving on the agenda, the civil penalty orders, and we will address the Healy matter. And we note for the record and welcome Mr. Healy and Mrs. Healy to this session. There's been an awful lot of paper expended in this matter, but let me, if I may, put it into context. The matter came before this commission. The commission undertook an evaluation, examination of all of the facts, and found the respondent would be responsible and imposed a fine. There was later a petition for reconsideration. The commission then acted and decided by unanimous vote to reconsider the matter. However, unfortunately, by the way of scheduling, that was done at an executive session and not in a public session. We thank and appreciate the work and diligence of the investigative division that has actively participated in this matter and filing the necessary responses to keep us on our toes. But we have also counseled with our attorney, and where we're up to now is, if the commission wishes, and I will make the following motion, is to ratify in public session what we did in the last, whatever date it was, executive session, that we will in fact reconsider this matter and it will be placed on an agenda in the future. And that motion has been seconded. All in favor, kindly say aye.
Aye.
Are there any opposed? Thank you. The motion is carried. This matter will be placed on a future agenda for reconsideration. I note again, Mr. and Mrs. Healy are here. I hope you understood what the process was today, and we certainly welcome any comments you may have since you are appearing on your own behalf. If you have none, we thank you for your interest in the matter, and you will be notified, I take it, Claire, of when this matter will be placed on the next public agenda. Thank you very much. Going on to civil penalty orders. These again are by way of consent. Raquel, you still with us?
I'm still with you.
Okay, I hope you're multitasking and taking care of your class while you're doing it. No, I'm kidding. Raquel, we are looking to you for the ethics on the agenda, the civil penalty orders, and these also are by consent.
Great. Thank you, Mr. Fryman. There are 3 civil penalty cases with proposed consent agreements that are now before this commission for decision. These cases involve respondents David Rayhard, Donald Bahana, and George Paratsky. Parties have submitted consent agreements proposing that the commission find that the respective respondent failed to timely file a statement of financial interest for calendar year 2010 and impose 1 civil penalty. Each of the respondents has paid the recommended civil penalty pursuant to the respective...
Excuse me, Ms. Bergen?
Yes.
Can you please speak a little louder? We can't hear you.
Oh, sure.
Okay.
Each of the respondents has paid the recommended civil penalty pursuant to the respective consent agreement and filed the delinquent form. Based upon my review of the facts, I am of the opinion that 3 consent agreements are consistent with commission precedent and are proper dispositions for these cases. Based upon my analysis and comments, I would like to make the following motion. I move that this commission approve the consent agreement submitted by each of the following respondents in the investigative division imposing civil penalties for failure to timely file complete and accurate statements of financial interest for calendar year 2010 as follows. David Rayhard, $100, Donald Bahena, $200, and George Paratsky, $150.
With that motion, I will second. Is there any comment, concern about each of those individually or as a group? There being none, all those in favor of the motion, please say aye.
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 Any negative-minded? And there are not. The motion carries. Moving on to the ethics session of our agenda, the civil penalty orders, and now civil penalty orders by default. Commissioner Calafello.
Excuse me, Mr. President.
Yes.
I think we have 1 late consent that came in, Mr. Walling, that still needs to be addressed.
A late consent.
Yeah,
Did Ms. Bergen have that?
I did not hear her address that one. I think it still needs to be done.
Commissioner Bergen, were there any added to the ones that you already had? If not, fine, and we can take care of it here.
I believe that it was something that was just supposed to be, taken care of here at the last minute. It came in at the last minute and...
Well, as long as it doesn't prejudice anybody at the last minute, we will be happy to address it today.
Yeah.
It's a consent agreement.
I was going to
Statement
say,
of
it's not
financial interest.
a major matter since there is a consent between the investigative division and the respondent.
Right, the respondent's expecting it to be dealt with today.
So we will deal with it today. What is the name or number? Did you now put these in our books? Do you have it? Commissioner Volk, would you recite that for us?
Sure. There's one additional civil penalty case with a proposed consent agreement that's now before this commission for decision. The case involves respondent Kevin Walling. The parties have submitted a consent agreement proposing that the commission find that Mr. Walling failed to timely file a statement of financial interest for calendar year 2010 and impose one civil penalty in the amount of $50. Mr. Walling has paid the recommended civil penalty pursuant to the consent agreement and filed the delinquent form. Based upon this, I'm of the opinion that this consent agreement is consistent with commission precedent and is a proper disposition of the case. Well, based on that, I'd like to make the following motion. I move that this commission approve the consent agreement submitted by Mr. Walling and the investigative division imposing a civil penalty in the amount of $50 for Mr. Walling's failure to timely file a complete and accurate statement of financial interest for calendar year 2010.
I would second the motion and ask if there are any comments, in as much as it's a consent order and hearing the recitation he's already paid. I would take it there are no objections, but formally for the record, I would ask all those in favor of the motion, please respond by saying aye.
Aye.
Are there any opposed? There being none, then that is approved as well. And we'll move right to the defaults. Commissioner Colafella.
Thank you, Mr. Chairman. There are two civil penalty default cases that are now before this commission for decision. These cases involve respondents Darlene Parker Thomas and Michael Arnies. Each respondent failed to file a statement of financial interest for calendar year 2010. These respondents did not file timely answers or respond to the civil penalty proceedings. Following review, it is my opinion that as to each of these respondents, the commission should levy a maximum civil penalty of $250 for the delinquent statement of financial interest. It is my opinion that the commission should also order these respondents to file their delinquent statements of financial interest. There is nothing of record that would constitute a defense or excuse for their non-compliance. Based upon my analysis and comments, I would like to make the following motion. I move that this commission levy a maximum civil penalty in a total amount of $250 against each of the following respondents for failing to file a statement of financial interest for calendar year 2010. Darlene Parker Thomas and Michael Arnies. Further, these respondents shall be ordered to file their statements of financial interest for calendar year 2010 within 30 days of issuance to the commission's order. I move that this commission adopt this motion.
There is a motion. Is there a second?
Second.
And there is a second. Discussion from anyone? Comments, concerns? If not, all in favor kindly respond by saying aye.
Aye.
Are there any negative-minded? And there being none, that is approved as well. Thank you, Commissioner. Another matter on the agenda that we have discussed on many occasions, I would turn to Commissioner McCurdy in regard to the de minimis exception to the Ethics Act.
Excuse me, Mr. Cronin, I'm sorry to do this again, but we did have two late-minute additions to the defaults as well, just within the last few days, and they were added to the agenda. Mr. Douglas and Wendell Douglas and Joseph Marino.
And I had an opportunity to review those when I came in this morning, if you'd like me to take those as well, Mr. Chairman.
I would be very appreciative, as with the rest of the commissioners.
Okay, there are two additional civil penalty default cases that are now before this commission for decision. These cases involve respondents Wendell J. Douglas and Joseph F. Marino. Each respondent failed to file a statement of financial interest for calendar year 2010. These respondents did not file timely answers or respond to the civil penalty proceeding. Following review, it is my opinion that as to each of these respondents, the commission should levy a maximum civil penalty of $250 for the delinquent statement of financial interests. It's my opinion that the commission should also order these respondents to file their delinquent statements of financial interests. There is nothing of record that would constitute a defense or excuse for their non-compliance. Based upon my analysis and comments, I'd like to make the following motion. I move that this commission levy a maximum civil penalty in the amount of $250 against each of the following respondents for failing to file a statement of financial interest for calendar year 2010. Wendell J. Douglas and Joseph F. Marino. Further, these respondents shall be ordered to file their statements of financial interest for calendar year 2010 within 30 days of issuance of the commission's order.
Thank you, Commissioner Volk. Is there a second to the motion? I will second the motion made. Comments, concerns, questions concerning the motion of these two additional matters? There being none, all in favor, please say aye.
Aye.
Are there any opposed? And there being none, they are approved as well. It should be noted, although that looked a bit ragged, we all have had from the latest distribution all that information. The only thing that I would appreciate it if we correct the agenda list right away so we have those additional names on it as quickly as possible.
Okay.
With that, moving on now to the de minimis matter that we have discussed at previous meetings. Commissioner McCurdy, you want to bring us up to date on it?
I'll try to, Mr. The committee was comprised of myself, Commissioner McCurdy, and Commissioner Bergen. We were tasked by the chair to review the de minimis exception contained within the definition of, quote, conflict or conflict of interest at section 1102 of the Ethics Act. The committee was to make a recommendation to the commission as to whether the commission should establish policies for applying the de minimis exception. The committee conducted an initial review of the exception, and the committee's suggestion the full commission received confidential legal advice from chief counsel regarding the exception. Although there have been a few non-commissioners who have expressed interest in such policies, it's the view of the committee that at the present time it would be best for the parameters of the de minimis exception to be continued to be defined by case law and commission precedent. Based upon my analysis and the comments I've made, I'd like to make the following motion. I move that this time this commission shall not establish policies for applying the, quote, de minimis exception contained within the definition of, quote, conflict or conflict of interest at section 1102 of the Public Official Employees Ethics Act. That is my motion.
I'll second the motion. It's not usual that we have a negative motion, but I must say this de minimis issue, which like the seasons comes up every so often and review it, and I think it is worthwhile for the citizens of the Commonwealth as well as for our function that we do that. But the motion is that the way things are now, relying on precedent and previous cases, that we need not try to change what has been going on for the last number of years. So with that comment, I would ask, are there any other comments from any commissioners? Since we have studied this, a committee has gone into it, our council has given us advice on it, and we have also discussed it at previous meetings. Is there any further discussion, analysis, comment? There being none, I wish to thank Commissioner McCurdy and Commissioner Bergen for their efforts as the subcommittee addressing this matter, and call for the vote of all those in favor of the motion. Kindly respond by saying aye.
Aye.
And are there any opposed? And I'm sure there are not. So thank you very much for your work on this, and we can put it away until maybe another year or so when someone brings up, should we look at this again. I will now turn to our Executive Director, Mr. Coutinho. Do you have some administrative matters you wish to bring to us and to the public?
No, we did have some payment schedules, but they've been taken care of, so there's nothing to report on that. And that would have been the only administrative matter at this time.
Thank you. With that, are there any other matters to come before this commission during this public session? From any commissioner, members of the audience? There being none, I would entertain a motion to adjourn.
So moved.
And it's been moved, and there is a second, and I'm positive there are no opposition, so the meeting is adjourned. Thank you so very much to all the commissioners and staff.